Welcome to season 2, episode 2 of my 2 cents a Zambian case law podcast with me, your host, George Chintankwa Malipilo. Today's case is P.C.Cheelo and 9 others versus the Zambia Consolidated Copper Mines Limited, who at times in this episode I'll refer to as ZCCM, or I will just mention the full name or the abbreviation, either one of the two. The full citation of the case is Supreme Court of Zambia Judgment number 27 of 1999. The issues for determination in this case were: does the High Court have jurisdiction to determine employment cases regarding breach of employment contracts, breach by the employer to pay terminal benefits or redundancy packages to the employee? The other issue was, can an employment matter be transferred from the High Court to the Industrial Relations Court? Now, as you shall see later, this is no longer the Industrial Relations Court, it's the Industrial Relations Division. Now, the brief facts of this case were as follows. P.C.Cheelo and 9 others were employees of the Zambia Consolidated Copper Mines. Now, P.C.Cheelo and his former employees belonged to the Mine Workers Union, while ZCCM belonged to the Association of Copper Mining Employers. On 29th August 1992, the said unions, which is the Mine Workers Union and the Association of Copper Mining Employees, signed a redundancy agreement. Now, as a result of the redundancy agreement that was signed, P.C.Cheelo and his former workmates were declared redundant. The 9 others were declared redundant. Now, ZCCM, however, did not fulfill its obligations as per the agreement. As a result, P.C.Cheelo and his former workmates were not paid their redundancy package nor their terminal benefits after they no longer were employees of the Zambia Consolidated Copper Mines. As a result, they decided to sue ZCCM. Now, when the matter came before the High Court, or an action was commenced in the High Court, where P.C.Cheelo and his former workmates were seeking the recovery of their terminal benefits and their redundancy package. However, ZCCM objected to the said action, challenging that the High Court had no jurisdiction to adjudicate or entertain this matter because it was of an employment nature. It had to be taken to the Industrial Relations Court at the time. Now, I've already talked about jurisdiction and its meaning. I think I have 1 or 2 episodes, so I will leave a link to those episodes in the description of what this case was determining. Now, the Deputy Registrar of the High Court, rather than dismissing the matter, decided to transfer the matter to the Industrial Relations Court. P.C.Cheelo and his former workmates then appealed to the Industrial Relations Court, and they were heard by a judge in chambers. Now, the judge who heard this matter in chambers observed that there was no actual provision in the law at the time. I think there's still nothing that provides for the transferring of cases from the High Court to the Industrial Relations Court. And therefore, he further advised them to say this matter must be discontinued so that you can seek leave to the Industrial Relations Court to file their complaint out of time. This is because at the time when the matter was supposed to be taken to the Industrial Relations Court, it would be outside the required period when, after there's a dispute, you commence a matter in the Industrial Relations Court, if my explanation makes any sense. So P.C.Cheelo and his former workmates, as a result of the decision of the Industrial Relations Court, decided to appeal to the Supreme Court of Zambia. Now, before the Supreme Court of Zambia, the issue that they had to determine was the jurisdiction of the High Court to adjudicate on matters involving employers and former employees or employees with regards to employment issues. So the Supreme Court, in determining P.C.Cheelo's matter, looked at firstly Section 85, subsection 1 of the Industrial Relations Act, which is Chapter 269 of the laws of Zambia. Now, this specific section talks about the current jurisdiction of the Industrial Relations Court, which is now the Industrial Relations Division, which has original and exclusive jurisdiction to adjudicate on industrial relation matters. Now, at the time they were looking at this case, the Supreme Court of Zambia, there had been an amendment to the Industrial Relations Act. In that, Section 85, subsection 9 of that act had introduced the definition of industrial relations. Now, that definition could be summarized as one, collective disputes, collective agreements, recognition agreements, matters affecting the rights, obligation, and privileges of employees, employers, and their respective bodies. The Supreme Court, in determining this appeal by P.C.Cheelo and his workmates, held as follows. It is quite clear from this subsection that the term industrial relation matters means collective disputes, collective agreements, or recognition agreements, or matters affecting the rights, obligations, and privileges of employees, employers, and their respective bodies under the signed agreement. In the instant case, the applicants are no longer employees of the respondent, and their claim is for benefits due to them under the redundancy agreement. To give the expression industrial relation matters a wide interpretation so as to encompass cases of breach of contract, wrongful dismissal, or claims of the nature before us, which could be tried by the local court or the subordinate court, would lead to absurdity. Now, we will talk about what all this meant under my 2 cents aspect, me looking at the case and what my understanding of the case is. Furthermore, the Supreme Court reversed the order from the court below, which was the High Court or the Industrial Relations Court. One of the two, I'm sure it's High Court. And it ordered that the High Court hear and determine the matter. Now, what this meant was that the appeal by P.C.Cheelo and his former workmates was a success. Their argument was that the High Court did have the jurisdiction to hear such a matter, while ZCCM argued that the High Court lacks the jurisdiction to hear employment cases for breach of payment, for redundancy payment, and terminal benefits. My 2 cents on the case in issue are as follows. First and foremost, a matter that has wrongfully been commenced in the High Court for Zambia cannot be transferred to the Industrial Relations Division or the Industrial Relations Court based on what the judgment was, as there is no provision for that. What you will need to do, therefore, is you'd have to dismiss the matter in the Industrial Relations Court, then commence a fresh action, or dismiss the matter in the High Court, then commence a fresh action in the Industrial Relations Court based on the directive that was given at the time in chambers by the judge, and also a look at the current industrial relations rules, which haven't yet been amended. We still use the old rules, so meaning the rules that were being used in the P.C.Cheelo matter by the Industrial Relations Court are the ones that are currently used. And if you have read the case of ZANACO versus Martin, is it Martin? I always forget the name. It's Martin. Is it Martin Musonda? Let me just go. Yeah, Martin Musonda and 58 others are Zambia Supreme Court, number 4 of 2017. That case talks about why, even though we have an industrial relations division, we still use the Industrial Relation Court rules found behind the Industrial Relations and Labor Act until such a time that those court rules are repealed and replaced. Those are the ones that we'll use. So That is the first my 2 cents take on the matter. Secondly, like I've mentioned throughout this episode, the Industrial Relations Court is now a division of the High Court. This is due to Article 133, Sub-Article 2 of the Constitution of the Republic of Zambia, Amendment number 2 of 2016, which provides for the fact that it is now a division of the High Court. Further, based on what the Supreme Court held to say industrial relation cannot be expanded to include certain aspects, it therefore means that the Industrial Relations Division or the Industrial Relations Court has limited jurisdiction with what it can hear, and this cannot be widened to include breach of employment contracts or failure to pay redundancy agreements or wrongful dismissal or terminal benefits. Therefore, the Industrial Relations Division or the Industrial Relations Court can only adjudicate on labor matters or disputes such as collective agreements, recognition agreements, collective disputes, matters affecting the rights, obligations, and privileges of employees, such as wage settings, working time, and working conditions. So, meaning, if you are a former employee, not a former employee, former employee, and you want to sue your employer, you can't take your matter to the Industrial Relations Division if you're claiming for terminal benefits, breach of contract. You have to take it to the High Court, because in P.C.Cheelo, they were saying these were not employees of the Zambia Consolidated Copper Mines. They were former employees. So they couldn't take the matter to the Industrial Relations Court, but the High Court. As a result, what the case of P.C.Cheelo was now bringing out was the subordinate court of the Republic of Zambia and the High Court for the Republic of Zambia do have jurisdiction to determine an employment matter. But that employment matter must be between the employer and the employee. So individual disputes that have arisen between the two, the Industrial Relations Court deals with a collective dispute. The trade union of the employer, the trade union of the employee. Collective bargaining, if that's a correct word. So, in the High Court, they're essentially dealing with the individuals themselves and the breach of their rights from an employment contract. In this instance, breach of contract, monetary claims for unpaid salary, failure to pay terminal benefits or redundancy package for former employees. So if a former employee wants to sue their employer, they can't go to the Industrial Relations. They have to go to the High Court based on this decision of P.C.Cheelo. That is what it is saying. Now, even though these courts have been given the jurisdiction, it must be noted that the subordinate court has a limited jurisdiction when it comes to listening to certain matters. Now, this is because when hearing disputes for contracts or damages claimed, the subordinate court can only hear matters involving an amount not more than 100,000 kwacha as it stands right now. And this is per Section 3 of the Subordinate Court Act, Amendment number 4 of 2018. So it is limited. So if they decide to hear a matter above 100,000, they have no jurisdiction to do so. Furthermore, even though an employer and an employee relationship arises in an industrial relations setting, the High Court, as I've already stated, does have authority to determine such matters due to the fact that the issue for determination in such cases are for wrongful dismissal, and these purely fall out of the law of contract. In addition, this implies that individual disputes arising from a contract of employment, like I have already repeated, are dealt with by the subordinate court or the high court, whilst collective issues arising from employment between the employer and the employee are only dealt with by the industrial relations court. So mostly with the industrial relations court, the employment matters it will deal with or ought to deal with must be between an employer and an employee. Because with P.C.Cheelo, they were asking for their redundancy packages and they were former employees of the company. Therefore, having seen the case of P.C.Cheelo and 9 others versus the Zambia Consolidated Copper Mines, what this case is essentially bringing out is the Industrial Relations Court or the Industrial Relations Division does not listen to all employment matters, even though they arise out of an industrial relations setting. So if it comes to the payment of terminal benefits and redundancy packages, and there has been a breach of that, or there has been a breach, or there is a claim for wrongful dismissal by a former employee of an employer, they go to the High Court and not the Industrial Relations Division. So that has been today's episode with me, your host, George Chintankwa Maripilo. And before I leave, I would still like to reiterate that this is not a podcast that is providing any legal service. It's just a podcast discussing case law, hence why we discuss the case and we dissect the brief facts and my 2 cents take on the said case and the meaning and what the case does have in this instance. Now, it must be noted that there have been other cases that have been decided by the Court of Appeal of the Republic of Zambia with regards the jurisdiction of the High Court and the Industrial Relations Court, and they did quote extensively from P.C.Cheelo. There has also been another matter before the Supreme Court as well. I think this one was more of a labor matter, and they also quoted extensively from the case of P.C.Cheelo versus the Zambia Consolidated Copper Mines with regards the issue of who has jurisdiction to hear matters of an employment nature and also labor issues. So the case of P.C.Cheelo is a fundamental case that will help you understand what court has the jurisdiction to hear cases that regard labor issues between employers and the employees, and also when you are challenging the issues of your redundancy packages or terminal benefits, which court do you take the matter to? So that has been today's episode with me, your host, as usual. I will see you next week with episode 3. Thank you for tuning in, and bye.